There's finally been some movement in the conspiracy case that came out of the Mallory Beach boat crash case. This case is so important, and it's very dear to me. I've been trying to piece this story together for a couple of years now. It's important because it's yet another case type that we refer to as a David and Goliath story. We have a broken-hearted, soft-spoken family who lost a daughter in a tragic boat crash. Regardless of how some may feel about the actual boat crash, this case is not about that. This case is about how far a person with money and power is willing to go to avoid blame or consequences. It's about a billionaire who, instead of fighting a fair case in court, chose to hire private investigators from two separate agencies, one of which is run by a former FBI counterintelligence director. Let that sink in for a moment and ask yourself, why? These PIs, including the former FBI director, began basically stalking not just the Murdaugh family, but the other passengers in the crash, asking about them at their universities, tracking these 19-year-old girls. In addition to these PIs, a journalist who normally reports exclusively on the Middle East, we see here speaking on C-SPAN, is suddenly writing about the Murdaugh family and ultimately ends up on a documentary where privileged photos and information known only to the attorneys working on the case show up. It's one of those stranger-than-fiction cases, and I want to get this puzzle finally put together for you to expose this ridiculous and honestly horrifying conspiracy put together out of what? Spite? Anger? Malice? Only Greg Parker knows why he chose to fight a battle of this magnitude against this grieving family. This case contains so many similarities with the Blake Lively case. A lot of the same motions have been filed, a lot of the same types of privilege have been claimed, and it also entails a smear campaign. This case is a little further along as well, so we've been able to see a lot of things already take place in this case that have yet to take place in the Justin Baldoni versus Blake Lively case. So going through this one can really prepare us for that one. Because of the scope of this case, it was decided some time ago that it would be assigned to one judge who would exclusively hear this case from beginning to end, instead of the typical situation where they appear before whichever judge is in session on the scheduled days. Unfortunately, there's been a lot of trouble keeping one judge. We started out with Judge Price, who was removed from his whole judgeship. We moved on to Judge Morgan, who ended up hiring for his law clerk a young attorney who had interned in Miss Barbier's office, one of the members of the defense team, during the summer that the boat crash case, that this case comes out of, was being fought and ultimately settled. At the family's request, he ended up recusing himself. So here we are on judge number 3. They say the third one is the charm, and I hope they're right. His name is the Honorable R. Keith Kelly. Yes, R. Kelly. But not that R. Kelly. We learn he was appointed to this case by the Supreme Court of South Carolina. Judge Kelly hits the ground running with big decisions that have been pending since, get this, 2022. Yes, for 3 years. This case has been tied up by none other than Mark the Time Waster Moore. My Murdaugh Krew will recognize him. If you ever need to stall a case for 2 to 3 years, he's your man. We've watched it happen with Russell Laffitte, and we've watched it happen here. He files endless motions, the longest in South Carolina, and when he doesn't get his way, he often runs to the Supreme Court of South Carolina, bringing everything about the case to a halt. To be honest, I'm expecting it to happen again any day now, since he's not happy with these rulings already. We start off with the motion to dismiss, or a 12B6. It was filed for Greg Parker on March the 9th, 2022. We've been talking about these documents a lot in the Blake Lively case. They're pretty hard to grant in legitimate cases because, as it states, a motion should not be granted if facts alleged and inferences reasonably deducible therefrom would entitle the plaintiff to any relief on any theory of the case. The question is whether, in the light most favorable to the plaintiff, the complaint states any valid claim for relief. those qualifiers make it very difficult to actually pass and be granted. This claim didn't pass, and we see he denied it. I'm not gonna lie, this next one makes me mad. Judge Price, the initial judge, went through all of the discovery piece by piece. This is exactly the process we talked about in the Blake Lively case, specifically the Jones Work Security Company that she's trying to claim work privilege for. The same thing was being done in this case, and the remedy was one we talked about, the standard that's set forth by the U.S. Supreme Court to have an in-camera hearing for the judge to look at all of the documents to determine whether or not there is privilege. Now remember, as I said, this is tricky because, as is often done, this is carried out ex parte, meaning it excludes one side of counsel. Ex parte meetings are very rare situations because it's hard to be fair when you exclude one whole side of the argument. But in this case, it's an abundance of caution in case work privilege does end up applying, because you can't unsee the evidence. But as we talked about with the Blake Lively case, the tricky part is if the attorneys are not honest. As I said, work product is about what's in the mind. Its theories, its ideas, its strategies. It's impossible to know what's in someone's mind. So you can't say it is so or it isn't so with any reasonable conclusion. In this case, in my opinion, we had a lot of dishonesty about what actually fell under this privilege. Judge Price became wise to it, but it was too late because he was leaving his position as a judge. It was his initial order, while being duped by the defense attorneys, that considered much of the material to be privileged. This was one of those situations where Mark Moore didn't like his decision for the things that he said were not privileged. He ran straight to the South Carolina Supreme Court and got an order from them by also not being completely truthful about the situation. The Supreme Court ordered Judge Price to go through each piece that defense was calling privileged, something he'd already done. But the Supreme Court order stated that anything that he had not reviewed would remain privileged. This led to a lot of material being found privileged by default. So there are still a lot of things marked privileged that in my opinion should not be. Things such as copies and email threads. The whole thing got very messy, and we'll get into those details later in the series, but for now, since we're just catching up on documents that have been filed, we're going to keep it short. When the new judge was assigned, Mark Moore flashed the Supreme Court order, and Judge Morgan ruled again on it, saying that the Supreme Court order would stand without investigating how it all went down. Now, Judge Kelly continues to uphold that ruling. My issue is twofold. That not only was it misrepresented in the first place, but the whole reason for the privilege had to do with the boat crash case that was still going on at the time. Mark Moore and Deborah Barbier had accused them of using the information from this case to win that case. But with that case settled now almost a year ago, I really cannot understand why there's even an issue of privilege anymore. But here we are. When your client is indeed guilty of what they're being accused of, your little bag of tricks to defend them is very limited. I made an episode once calling Mark Moore a one-trick pony, but I think I sold him short. He's a two-trick pony. All he has done in this case is 1, tried to conceal all of the evidence by claiming privilege, and 2, tried to disqualify opposing counsel. He's done these two things over and over again, and the changes in judges has helped drag this out. It sounds like this judge is not going to let at least that happen though, and so I'm pleased to see it. This ruling was on one of the motions to disqualify plaintiff's counsel, Mark Tinsley and Tabor Vaux. In his ruling, he states this court recognizes the drastic nature of disqualifying a party's chosen counsel. This court finds that the high standard of proof required to show that disqualification is warranted has not been met. Specifically, the court finds that the actions and inactions of plaintiff's counsel were not instances of misconduct, nor violations of the professional standard of ethics. So keep that sentence in mind. It's going to come back again. So this was the happiest news, I think, of all the decisions he made, as one of our favorites gets to remain on the case. This one is very much based on the last. It's a motion to stay discovery. We've seen this filed also in the Blake case. We saw the New York Times file this motion. They were granted it. That means that all this time that the judge is waiting to make his decision on whether or not the New York Times gets dismissed, no discovery is being taken from them. In this particular case, the motion was to stay while the court decided whether or not to disqualify counsel. Now that the court has ruled on that, there's no reason to stay any discovery. This next ruling is also about discovery, and it is huge. Along with claiming work product on a lot of discovery, they were also claiming privilege between themselves and these private investigators. Now, as I said earlier, this is similar to the Blake Lively case because it talks about a smear campaign. In this one, we refer to it more as a conspiracy case, but it definitely involved a smear campaign. But all of this time, all of this had been considered privileged. The Beach family was not able to find out who hired these private investigators. Who were they contracted with? Who was paying them? What were they paid exactly to do? What were they doing with the information that they gathered? Finally, this motion gets granted, and now they can get to the bottom of all of these questions. The court ruled this way because he repeats Rule 26B, which we've discussed so many times in the Blake case, so I'm not going to read it, but he says the entire thrust of these rules is for full and fair disclosure to prevent a trial from becoming a guessing game or one of surprise for either party. This court orders defendants Max Fertotti, who is the former FBI director, Henry Rosado, his partner, and Private Investigation Services Group, that's the company they own, to respond to plaintiff's discovery request with specificity within 30 days. This is huge. Moore had basically tied Tinsley and Vaux's hands by not letting them get to the actual evidence of the case for all these years. They are so smart to have sorted out what happened here with the very little bit they had to go on, but without access to the actual evidence, you can't go forward with your case. You have to prove it. You can't say we suspect this. So he really needed these investigators to admit on record who hired them to investigate these people. Now, after this decision is made, and I have to say, Mark Tinsley wouldn't be the attorney we love to see in action if he hadn't filed this so quickly that it actually beat the judge's order being filed on the docket. Not just beat it, but beat it by a whole day. Look at this. And by the way, looking at this document, for those of you who follow my coverage on the Justin versus Blake case, this is what I miss so much. These formal filings. They're labeled exactly as they should be. They have the caption, they have the name of the document, whether it's a motion to quash, motion to compel. Because it's a state court case and not federal, the stamp is on the side instead of the top. But in the stamp is not just the date, but even the time. It's so beautifully organized, and I just had to bring this up because I just cannot get used to these Dear Judge letters that they file in New York instead of these formal documents. Sometimes it's hard to figure out what to name them, where in these cases, they're already named for you. So in this motion to compel, he says an order requiring defendants Max Fertotti, Henry Rosado, and Private Investigation Services Group to fully respond to the interrogatories and requests for production served upon them back on December 11th, 2024, pursuant to Rule 37 of the South Carolina Rules of Civil Procedure. So they had filed a motion to compel back on February 17th before the judge's order. The defendants responded to these, but in the responses were these objections. So here he comes with this document with 3 years of outrage behind every word and says these private investigators have been ordered to fully respond with emphasis on the word fully. They have to, at long last, give these answers. He goes on, their refusal to answer is based on private agreements not to disclose the identity of their employer in these matters or the person who hired them, or disclose the work they were asked to perform. So they want to know who told you to do this and what exactly did they tell you to do. But he says these objections do not prevent the disclosures requested by the discovery pursuant to the applicable rules of law. These evasive answers do not provide any information other than, and this is important, confirming their involvement and the involvement of Parker and Parker's co-conspirators in these matters. And we can see that by these answers. So for example, question number 1 asked of the names and addresses of persons known to the defendants concerning the facts of the case, and indicate whether or not written or recorded statements have been taken from the witnesses and indicate who has possession of such statements. So, names and addresses. This is one of the very first types of discovery that's asked for. But look what C is after they identify themselves in A and B. Undisclosed client of their company. And they say that they have an NDA with this client. They will only disclose it when ordered by the court. Well, they've been ordered now. This answer still could be anybody. But number 4 says identify any and all work of any kind, and it lists different types, on behalf of or were a party to or were privy to any way connected with, for or concerning Gregory Parker. Now it lists not just Gregory Parker, but his company, Parker's Corporation. The next 2 names, Blake Greco and Jason DeCruz, are attorneys. Blake Greco is his personal attorney, and Jason DeCruz is from the firm Baker & Hostetler, and that's a huge firm with offices everywhere. It also lists the investigative journal. This is a journal in London, and we're going to go there at some point in this story. It also involves Mohammed Fahmy, and now a name you've already heard, Greg Roman, the Middle East Forum, the Georgetown Group, or Gregory Parker's lobbyist principal. So basically, they give them this list. It kind of says, we know it's one of these people. We just need you to tell us which one of them it is. And boy, were they right. Look at the answer. We didn't do work for any of the above named persons except for one person on the list. Now we know they're right. All of these people are affiliated in some way with Greg Parker. So anyone on this list is a bingo. And they say one person on this list. But they won't say because of this NDA. Well, now they have a court order. So they now know they've been protecting, ultimately, Greg Parker. Question 6. They say to identify any and all conversations, and they list different types of them. Some of the people already mentioned, along with a new one, Vicky Ward. Vicky Ward, who's also a reporter. She was an executive producer on that documentary. She's also someone, those of you who've been following this case know her. She's also someone who approached Mark Tinsley to try to get an interview. And he ends up getting lots of information from her. The answer? They had communications with their client that they'll identify when ordered by the court, and no other communications with any other person listed. So it seems that they served a purpose, but they weren't in contact with everyone. So it seems this whole investigation was compartmentalized, keeping people from knowing everything that was going on. They just knew their part of it. Now, Vicky Ward comes up again. Because of his communication with Vicky Ward, he knows that she was in contact with these private investigators. So now in their answer, they say that they had 2 phone calls with Vicky Ward relating to her investigative work. And we know that she was getting information for the documentary. So now we're seeing they were connected to someone connected to Greg Parker, and they were connected to the woman who put the documentary out. Do you see the pieces fitting together? And now this one is an excellent question. They give a list of important terms that they want to know if these came up in any of their searches. These are all terms that are very specific to the accusations of the smear campaign. Now remember, they have to answer this honestly because these things can be forensically extracted from their devices. So if they lie, it's going to be caught. And these terms don't disappoint. They knew exactly what to ask these guys for. So question number 7, list all messages, texts, emails, or correspondence of any kind sent or received that contains any of these search terms. And this is their biggest answer yet. They say no correspondence of any kind with any of the parties, with one exception. They did conduct research for their NDA client on publicly available information to better assess the quality of the investigation conducted by law enforcement personnel on all matters connected to the Murdaugh family in the Low Country. And this is one of the things they were looking for. So there were a lot of accusations made, and if you look at the police reports, it really does seem there was a problem with certain law enforcement slanting things in Paul's favor. So this is what they were looking into to see if there was impartial treatment by law enforcement authorities and favoritism being provided to the Murdaugh family. Now, remember, this has absolutely no bearing on their actual legal case. The only reason they would want this information is to try to make the Murdaugh family look bad. And now this little tidbit, this is going to come up later. Please keep this in mind, it's very important. These private investigators contact Tabor Vaux' law firm on July 10th, 2019. This is just a few months after the boat crash. They also contact these other law firms, and this is all in the span of 3 days. They ask to see if these offices are renting out office space. Are you wondering why? We'll get to it in one of the later episodes, but it turned out none of them had any space for rent. This answer's quite long, it's still going on. And you know when someone over-explains, there's something behind it. They could have stopped there saying there was no space for rent. But the fact that they go on to give this explanation that sounds defensive should get your spidey senses tingling. This office space search occurred some 2.5 years before the events relevant to this outrage lawsuit and before Vaux joined the Beach outrage lawsuit. Are you wondering why they mention that? So they also conducted research on Sarah Capelli, a private investigator, after being provided discovery information from the plaintiffs. The information identified Capelli, though being represented by other counsel, as having communicated with plaintiff attorney Mark Tinsley and Stephen Peterson, an unlicensed investigator working for Charleston attorney Andy Savage. So, Sarah Capelli had also done investigative work for Greg Parker. She's in fact suing him right now, and we've covered that case. So these investigators are investigating her and her communication with Mark Tinsley. Not only do they do that, but they file an ethics complaint regarding her comments and contact with Mark Tinsley and Peterson. She gets investigated, and she ends up reprimanded. So these people are not just looking for dirt on the Murdaugh family or the boat crash victims. Now they're looking for dirt on the Beach family's attorneys. Question 8 asks them to identify the date of and all persons who signed any and all messages, correspondence of any kind between these defendants and the Gregory Parker Group. And this is any other person, entity, investigative reporter, journalist, correspondent, columnist, broadcaster, writer, or blogger, or the person or entity paying any portion of attorney's fees for these defendants. The answer is that they corresponded with their client on June 2nd, 2020, and signed a contract on June 8th, 2020, and that they will identify the client when and if ordered by the court. They communicated with their client until the client was unable to secure additional funding, which was on or about August 16th, 2021. So they worked just over a year until the money ran out, which is interesting. Why did the funding stop? And then their client referred Vicki Ward to them to provide local logistical support during her visit to the Low Country. They say they had 2 calls with her, but they never met her or provided any services or materials to her, and that after this time they had no additional contact with her. And we know that on Vicki's trip, she was contacting Mark Tinsley and trying to meet up with him and wanted to film him for what she called the sizzle reel. So this is connecting everything, even these answers that aren't fully put in there. Because they identify it with someone from this list, we know it's connecting. If you guys knew how excited I am to see this story being confirmed right in front of my eyes. I mean, I can't even tell you. I have been so outraged by the stonewalling that's been allowed for these literal years. The mistreatment of these amazing, talented attorneys. These attorneys have been accused of misconduct and painted as if they've abused the court, when all they ever tried to do was fight for their client against a powerful billionaire who played dirty, allegedly. As it turned out, he thought he did all this untraceably, but they were smarter than he gave them credit for. And when they, with the little information that they got to have, because he blocked everything else, when they were able to take that little bit of information and unravel this scheme, his unscrupulous attorneys had no shame and no problem maligning their fellow officers of the court, to the court, and even to the South Carolina Supreme Court to pad their own pockets. In my opinion, it's disgusting. It's despicable, and every other word that holds that meaning. This is the ugly side of the legal system. Just like in Blake's case, we're seeing it with Ezra and Samantha, and now Michael Gottlieb with the accusations that are being leveled against the 3 of these people. A sham lawsuit, a sham subpoena, extortion. They say you choose the lawyer that's most like you. In this case, and in Blake's case, it really seems true. Now, the rest of the questions in the interrogatories are all denials, so we're not going to cover that, because that just gets frustrating. But let's get back to this motion to compel that actually hit the docket before the judge's order. So just as we saw in Justin and Blake, they also were to attempt to work out the problems amongst themselves before coming to the court for help. And we see that here, where they say, we communicated by phone with counsel for the private investigator defendants in an attempt to resolve the issue, only to be told that the deficiencies in the response are based upon an apparent belief that the NDA between the private investigator defendants and this NDA holder prevent them from being able to respond without an order from the court. Now, as we just saw in the few answers that weren't even completely answered, they definitely have information related to this case. And we see it says, the identification of the people or entities for whom the private investigators worked, as well as the work they were asked to do and what they actually performed, goes to the heart of plaintiff's case in identifying and in demonstrating the connections, efforts, and ultimate conspiracy to harm the plaintiffs by or among the various defendants. Because the responses that were provided to the discovery requests actually indicate that the PI defendants have discoverable information about these matters and that the NDA holder is a witness to facts concerning these matters, full responses to the requested discovery should be compelled. Plaintiffs have contended from the beginning that the defendant's surreptitious behavior involved behind-the-scenes actions and straw men to divert the attention away from Greg Parker's deplorable and despicable acts and the Parker defendant's efforts to carry out his wishes. And they've always used this term in these documents of straw men. They've always said that there was behind-the-scenes behavior by Parker and that he had straw men out in the front. Now, a straw man is a person that doesn't really have interest or participation, but they serve as a stand-in for the real participant who secretly controls activities. It can be in a case like this. It can be where the actual owner is not permitted to act, but another purpose they serve is to distract the other side from the real issues or waste the opponent's time and effort. So that's what a straw man does. It goes on, Mr. Grantland, as counsel for the private investigator defendants, has informed plaintiff's counsel that the PI defendants' only objection to responding to discovery is their concern about breaching this NDA. They also say on April the 3rd, 2025, that plaintiff's counsel received a letter from counsel for the PI defendants clarifying communications between the PIs and the NDA holder. And it confirms instructions to the PIs about authorizing a limited release to discuss their work to several news outlets and SLED. And that's Exhibit B. Now, you may recognize the name Grantland. He was recently a part of Corey Fleming's federal case with Alex Murdaugh's insurance company. In this case, he's one of the attorneys for these PIs. And in this letter, what he discloses to Mark Tinsley is that according to my clients, the updated contract date with their client, the NDA holder, was on July 31st, 2020. The last contact they had was on August 27th, 2021. I am informed that Max and Henry received an email from the non-disclosure agreement holder on June 25th, 2021, giving them instructions about authorizing a limited release to discuss their work to several news outlets and SLED. The email prohibited disclosure of the identity of the non-disclosure agreement holder. I informed that my clients had no invoices to the NDA holder after December 20th, 2020, and very little contact until June 25, 2021 email and the referral to Vicky Ward. So the NDA holder, whoever this go-between was, even that person kept contact pretty minimal. But they were instructed to discuss their work to several news outlets and SLED. So this information they collected, they obviously wanted distributed. Now it's going to be a matter of figuring out which news outlets this information was provided to. Now see, this is what the inner workings of a smear campaign look like. You see people being told to get specific information and distribute it. You see investigators to get that information. It's completely not the same as with Blake getting criticized for the clothes that she selected in her movie, or her tone-deaf interviews, or her rude behavior. This stuff had to be sought for. If a smear campaign had been dealt on Blake Lively, this is what it would have entailed. It wouldn't have been stuff related to the movie. That would have been, as I've said so many times, the last thing Justin Baldoni wanted. Anything to connect to his movie. It would have been stuff like this. Stuff you have to investigate and then leak to specific news outlets, not independent TikTokers making fun of Blake. So he says after getting this information, he wants to narrow the scope that they want to compel to this specific area and provide new interrogatories based on this newly discovered information. And so we see the list of what they want. He says for interrogatory number 1, the PI defendants acknowledge that the undisclosed client is a witness, but because of this NDA, they won't disclose the name unless ordered by the court. The court should compel this answer. Number 2, they ask for each witness concerning the facts of this case to set forth a summary sufficient to inform plaintiffs of the important facts known to or observed by such witness, provide a copy of any written or recorded statement. Again, they said they would only disclose this when compelled by the court, so they asked the court to compel this answer. Interrogatory 4, they had asked them to identify all work of any kind or any kind of research that they conducted on behalf of the defendants or their agents. They refused to answer till ordered, so they asked the court to compel. Interrogatory 6, they asked them to identify any and all conversations, any type of communication, including the date and the substance of the communication between themselves and Parker, his co-conspirators, or their agents. Again, they refused to answer without an order, so they asked the court to compel. Number 7, list all messages and correspondence of any kind received by these defendants containing certain search items. Remember that long list of items. They refused without an order, so they asked the court to compel. Interrogatory 8, they asked them to identify the date and all persons who signed any and all messages, texts, emails, or correspondence of any kind between themselves, the individuals listed as defendants, or any of the individuals or entities known to be associated with them. Again, refused without an order, so they asked the court to compel. And now we get into the request for production. They're asked to produce the contract between themselves and this NDA holder. They say not till ordered by the court, so the court should compel this production. Request for production number 4, produce any and all surveillance reports, photographs, videos, given or collected in any capacity. Again, they say only when ordered by the court, so they request the court compel this production. Production number 7, produce any and all phone calls, text messages, emails, or any form of communication between the defendants and the other known conspirators or their agents. Again, when ordered by the court, so the court should compel this production. Last one, request for production, produce a copy of their entire file and all documents and communication of any kind, and the defendants state they will produce the file when ordered by the court, and so they ask the court to compel. He signs off by saying that plaintiff's counsel certifies that he has complied with Rule 11 and has attempted in good faith to resolve the matters contained in this amended motion with counsel for the private investigators' defendants. Now, we've heard a lot about Rule 11 in the Justin and Blake case. These are rules that attorneys must follow, and 11 is specifically dealing with signing pleadings, motions, and other papers, representations to the court, and of course not following this rule leaves you at a risk of being sanctioned for misconduct. And this was submitted by Mark Tinsley, John Nichols, and Tabor Vaux. Now, after all this is taken care of, one would think that from here, following the court's decisions, that with obstacles lifted, all should go smoothly, right? Wrong. Not if Mark Moore can help it. So on April 21st, he replies, and guess which trick Mr. Two-Trick Pony wants? You have 2 guesses. If you guessed he's back on the motion to disqualify counsel, you're right. He files a motion to alter and or amend the court's order of April 11th, 2025, denying the Parker's defendant's motion to disqualify plaintiff's counsel. Not only that, he requests a whole hearing for it. You saw the court's reply. They couldn't have been clearer in their decision. But that never matters to Mark Moore. This motion is 10 pages long. It comes with a 115-page court transcript and an 11-page timeline that he's been sharing with the court for years now, trying to prove attorney misconduct. It comes complete with a photo, which I think is the best part, because we get to see Mark Tinsley's stunningly beautiful wife, Stephanie, which you're going to get to know a little bit better this summer when she shares an announcement. Now, this timeline, not one judge has bought it. Now, with this being a new judge, he just had to try again. This letter throws me at first because it starts off reasonably enough, saying he knows this is rarely granted, but he's filing it to preserve arguments for an appeal later. And I thought, wow, he gets it this time. Because, in case you didn't know, if they don't bring up objections along the lines of the lawsuit, they can waive their chance to appeal it later. So sometimes you see things and it's like, why are they asking for this? They're never going to get it. And they know they're never going to get it, but this is what they're doing. They're preserving arguments for appeal later. I thought, wow, he's coming around. But alas, I turned the page and I found the Mark Moore that we've become used to in point 2. The particular facts of this case, respectfully, require disqualification. So he basically says, Judge, respectfully, you're wrong. And so he asks for oral arguments on this motion, and he wants these exhibits that he's attached to be referred to for this hearing, not just the ones here in this document, but it's to include an affidavit of a Professor Nathan Crystal. We've been through that before. It's a professor that agrees with him that counsel should be removed, and 3 other documents that have been filed along the way. You'll see that when I tell you that he is a 2-trick pony, that I'm not exaggerating. We've already been through all of his requests to keep these things privileged. Now you see before you the 3 previous documents and their file dates where he's tried to get these attorneys disqualified. And this doesn't include the hearings that he's tried to do it. And he loves hearings, by the way. He's not very good at them, but he loves them all the same. Now, are we going to look at all those attachments and transcripts? To quote from Jane Austen's Pride and Prejudice, "I shan't sport with your intelligence on that score." And really, we don't have to, because 3 days later, Judge Kelly to the rescue said, "No way, Jose." He doesn't even give him an explanation. He says, "It's denied." Because he already told them the reasons it was denied. He didn't find misconduct. He said the bar is very high, and that's that. Now, I've been holding my breath ever since, because this is the usual time that he hightails it to the South Carolina Supreme Court. So, no promises that he's not doing that as we speak. Now, does it feel like I'm being too hard on Mr. Moore? Sometimes I'm afraid I do go too hard, just like I do with Dick Harpootlian. But it's because, as I just explained with Dick in my last episode, these guys used to play on the side of the good guys. It's not a small feat to get a law license and pass the bar. You go through so much, and I always like to think that people who go into this field do it because they love the law and they want to see justice served. And I picture them eager when they start out, that they use their energy to put the bad guys away. I don't know how you go from that to the dark side, where every ounce of the part of you that wanted to see justice served, that wanted to put the bad guys away, is stripped from your soul. And you not only give a vigorous defense for your unmistakably guilty client, but you hurt good people in the process. Or you put bad people back out in the population where they can hurt people. In this case, they hurt not just the attorneys here that are being maligned for these 3 years, but Mallory's family. According to these allegations, Greg Parker got a hold of photos of her body as it was found 8 days after the crash. She was 19 years old. She's their firstborn child, one of 2 children, and he sold them or provided them to a documentary who released a trailer that they called a sizzle reel. Think about those words, and then you know what this trailer was meant to do. And what's in this trailer? Those photos. Barely blurred. As I mentioned, this family had to avoid all social media for a while for fear that that video or those photos were going to pop up. They had to hear people talking about it. People run into them. "Oh, did you see Mallory?" They were still very much in the beginning stages of mourning for Mallory. Not that it would be okay even now, but especially then. The things that they endured because of the wreck happening in a Murdaugh boat at the hands of the youngest Murdaugh son were already things that most people don't have to deal with on top of their loss. But then they had to deal with the smear campaign by Greg Parker. They had to see things being put out by news outlets to cast blame on their deceased daughter. That serves no purpose. And then more, like Dick, at the end of a long career, that time in your life when you get to say, "Hey, I don't have to put up with the garbage anymore. I get to choose my cases. I get to choose what I spend my time on and my energy on." And at this point in life where he could say, "I don't have to take any case I don't want to take. I can slow down. I can enjoy what life I have left." And this is what he chose. It's different than a public defender who has no choice about the cases he's assigned. And everybody deserves a defense. I understand that. But when you have a choice, he wasn't going hungry. He didn't have children to feed. He wasn't losing his home. This was a choice of greed at the cost of any morality or integrity that may have once existed in him. His client, in my opinion, is guilty. There's no way Mark Moore can't see that. We can see it based on the little evidence we have. He sees it all. And he doesn't just settle for doing his job. You could almost excuse him if he did. But he fights dirty. And like I said, hurts people along the way. This is the same man who chose to defend Russell Laffitte in federal court, in state court, in multiple cases. The man who stole from orphans, widowers with a house full of kids to raise. The man without whom none of Alex's thefts could have happened. And Moore delayed, and delayed, and delayed, and burned up money like it didn't matter, knowing that every dollar he took was $1 the victims wouldn't get in the end. For this reason, and so many more, I have no patience or compassion left in my heart to try to speak in a neutral manner when I speak about these men. I love the law and the reasons that it was created. It was meant to bring about justice. When it was written, it was to bring fairness and relief to people who've been harmed. It's been twisted beyond recognition to what it is today, and I admire and respect the ones who still fight for the true meaning of justice. But guys like this? No. Just no. And on that note, Greg Parker filed his answers on April 25th, no surprise, denying absolutely every allegation and asking for the court to grant him dismissal from the lawsuit and pay his attorney's fees. We're not going to read that one. On May 15th, Greg Roman, the reporter who, as I said, exclusively reports on the Middle East, but suddenly puts out a huge article on the Murdaugh family and starts blogging about them, filed a motion to quash the subpoena that was served to him. He not only wants this subpoena quashed, he wants a whole protective order preventing the disclosure of such records in this action, designed to stop any future subpoenas. Now here's another similarity with the Justin and Blake case. He's using the same reporter privilege that Megan Twohey and the New York Times used, because he's a journalist. But this time the information sought isn't about what he reported. It's about whether or not he was hired to put out this sort of hit piece and who hired him. He is also one of the people on the list that could possibly have hired the private investigators. There's also the fact that this was way off of literally everything else he's ever reported on before or since, which makes it stand out as suspicious. But his objections to this subpoena are that it's for any and all of his financial account records and statements. This is for him and any name he goes by, and also his business. It dates from February 24th, 2019 to present. He says that he maintains confidential relationships with sources and uses his financial accounts to fund his journalistic activities. He says revealing these transactions would reveal confidential sources, areas of investigation, and proprietary journalistic methods. He says for his business entity that it conducts both journalistic activities and private consulting services. They have binding NDAs with their clients and vendors, and that these would be violated by disclosure. He also says he's a resident of Pennsylvania, and so is his business, and that he has no connection to Hampton County, South Carolina, except for that big old report and all that blogging. Makes it even weirder, doesn't it? That he's not even from South Carolina. So why would he report on this? And the interesting stuff is he was reporting on this long before the murders, long before the documentaries, long before anyone outside of this small area of South Carolina knew anything about these people. There's so many reasons that it's suspicious. And next we see that dreaded news-gathering privilege that just makes me want to cringe because it's almost impossible to overcome. I'm hoping that because, as I mentioned, this is a different sort of request than the usual. This isn't about his actual news-gathering activities. This is about who hired you. And I'm also hoping that it qualifies for these exceptions that he mentions. If we look at them, they are material and relevant to the controversy. They cannot be reasonably obtained by alternative means because if we don't know who paid him to write it, there's no way to know whose bank information to look for payment from. We also know Parker used straw men. That really narrows him down to the only source. And 3, this information is necessary to the proper preparation of the case. This case is all about finding your way through the straw men one step at a time to get to the source. Greg Roman is probably one link in this chain. Without him, maybe they can't get to the next link. He's not under investigation himself. He's not a named defendant. So maybe this exception will apply. But now we get to something that may be troublesome. There's a mention of this Uniform Interstate Depositions and Discovery Act. This was something that was put in place about a decade ago, I think, and it was put in place to not cause an undue burden to people receiving subpoenas. This applies to anyone beyond 100 miles from the issuing place. We just saw this in the Justin and Blake case. When the subpoena was sent to Taylor Swift's law firm that was in D.C., it qualified for that act because it was beyond 100 miles. So how that's supposed to go is that a subpoena beyond 100 miles is supposed to be served under the authority of the local court of whoever's being subpoenaed. Because any court action, such as this motion to quash, for example, is supposed to be held in his local court. So why this could be troublesome is that this will not go by the laws of South Carolina. This will go by his local laws in Pennsylvania. I'm not familiar with their laws at all, and I didn't have time to look into any cases from there yet. But all of these decisions will fall to their state laws, and I'm afraid they might be as strict or nearly as strict as New York's. And that would be awful. Then he goes on about his confidential banking records again, and he calls it a fishing expedition. He says that it's overbroad, and that it would reveal confidential business relationships and would break NDAs with his clients, so repeating what he already said. But all hope is not lost. Because of those exceptions, these could be overcome simply by narrowing the scope of the next subpoena, filing it in his local court, and also I was thinking, just like the Justin and Blake case, they deemed some of the discovery attorney's eyes only, so that if there was confidential information, it wouldn't go to any of the clients. It would only be given to the attorneys to see. So there are ways to overcome this, and hopefully they can find one. He asked for it to be quashed, and again he's trying to avoid a new subpoena with a narrower scope by asking also for a protective order, which would prevent him from receiving any more. He also asks that until the jurisdiction and procedural issues are corrected, to stay the subpoena, which means he wouldn't have to comply with it, provide any information, until this is dealt with. We see the subpoena made by Tabor, and we see all the things that it asks for. He also includes an affidavit that repeats all the claims that he's just made in the motion to quash, and there hasn't been a motion in opposition filed yet. I'm not sure if they will, or if they're just going to withdraw this one and send a new one. That brings us to the end of the documents that have been filed up to now, except for the scheduling order that the judge prepared. So these are the important dates. All discovery should be completed by November 1st. Mediation conducted no later than December 31st. All pretrial matters shall be filed by February 28th, and all pretrial matters shall be heard by the week of April 6th. And he set the trial date for the week of May the 4th. Now, this is all, of course, if the case doesn't settle. Now, for the boat crash case, the one that this came out of, it got pretty far along before Parker finally broke down and settled. So we'll see what happens with this one. I imagine he's not going to like a lot of this evidence coming out, so I think it's going to depend on how much is able to be discovered. I feel like if this stuff starts leaking and showing his guilt and his underhanded ways, that it's going to be in his best interest to try to settle. Again, we won't see most of this in this discovery phase. We'll only know if, like, for example, this subpoena to Roman, if there's an issue that the attorneys can't resolve, that the court has to deal with. And then we'll get to see the filings, but otherwise, we'll have no idea what evidence is coming in. It's always nice when it happens, so that we get a little sneak peek. I kinda hope this does go to trial, just so all these facts can come out. Because this is just so unusual, and just so awful. And just the inner workings of a smear campaign. The laws have to keep up with changes like this in society. You know, years ago, we didn't have to worry about a smear campaign like this. There were little things put out in the newspaper. Very localized. But these kind of things with bots and trolls and private investigators and then leaking them to news outlets, it's going to take cases like this to create new laws to prevent these things from happening in the future. So unless this actually makes it to court and decisions get made by a judge, we're not going to have those laws made. So for that reason, and also, I just want to see these people vindicated. I'm really hoping for a trial. I'll keep you posted on anything new that comes out. Till then, this is Cassidy O'Connell saying stay well and stay tuned.